Welcome to the second day of our international conference about cyberspace and law and technology. My name is Giovanni Ziccardi. I'm the director of the Information Society Law Center of the University of Milan. And we are starting a very interesting day, especially related to cybercrimes. In this morning from 9 to 12, we will discuss about several topics, about legal and ethical challenges in the use of open data, about a new concept of privacy and with some ethical and philosophical consideration. We will discuss about platforms and especially a sort of international overview regarding Europe and China. Then we will discuss about Metaverse crimes and new examples of computer crimes online. Then we will discuss about the freedom of expressions and especially the rights of the victims. And finally, we will discuss about regulation of deepfakes. As you probably know, we selected several excellent papers and studies for our conference. And so I really welcome our speakers of this morning, Ionida Milai Weishar, Emanuele Brambilla, Urbano Reviglio and Giulio Santoni, Emilio Sacchi, Guilherme Peixoto Migliora, e Sinem Ozigit. And we will divide our morning in two slots. And we will start soon with the description of the main research topics of the first three speakers. Then we will collect the comments coming from all the channels we are streaming in and have a brief discussion with the authors of the papers and of the studies about their research lines and the most innovative aspects. Feel free to comment on Facebook, on LinkedIn, and on YouTube. We can see in real time here in the background your comments, and we will forward in real time also the comments to the authors. So I welcome the first speaker of our conference, Ionida Milai Weishar. She sent us a very interesting and excellent paper regarding legal and ethical challenges in the use of Web 2.0 open data. I kindly ask to Ionida to use a minute of her presentation to explain her work, her position, and research lines that she is following in these days. And then she will have 20 minutes to explain the main aspects of her works. So I kindly ask to Giulia to put online on streaming Ionida and her presentation. And we are here in the background, Ionida, for any help. And good luck, and we are listening to you.
Thank you very much, Professor. It is with great pleasure that I'm participating at this forum, and I'm given the possibility to share my research with you. My research, let me first present myself. My name is Ionida Milai Weishar. I am assistant professor in technology, law, and human rights at the University of Groningen in the Netherlands. The research I'm presenting today has been developed in the framework of Horizon 2020 project criteria that is sponsored by the European Commission. This project is about the use of artificial intelligence and open data from social media for migration purposes and for border control. However, in my presentation, I will be more abstract and talk about open data from social media in general. Can we please share my slides? Yes, thank you. So as I said, my agenda today is to talk about open data from social media in general. And I will first define the problem. What do I mean with open data from social media, or as they are randomly called, Web 2.0 open data? Well, the term refers to all data that are available on social media without any privacy filters. And the reason for this is either because we, when producing content on social media, do not place any privacy filters, or because others, our connections and friends, publish data on social media without privacy filters. Currently, there is no specific regulation regarding the regulation of open data in general, and specifically regarding open data from social media. As a result, the general legal regime is applicable. Thus, the framework that we have with regards to protection of personal data, as for example, the GDPR, is applicable to open data from social media as well. Also, with regards to the European data strategy, open data from social media have not been receiving a special attention. In the European strategy, they are mentioned once as an example that they can be used, for example, for complementing other reports and other studies. However, we have a disbalance between the regulation of this data and the attention that these data are receiving in official documents, and the real use of open data from social media in reality. What we find out is a lot of evidence for actual uses in various fields, especially with regards to intelligence activities. More than 90% of the workable intelligence nowadays, it's evaluated to come from open source data. Furthermore, with regards to risk assessments, there are many instances in which open source data from social media are used for risk assessments, for complementing other reports, etc. And another field that is worth being mentioned is use of this data for training artificial intelligence. This disbalance between regulation and use of this data translates into some problems for the protection of the human rights system of the individuals. Because what we see, and what I will argue in a moment, is that the safeguards for open data from social media are in reality watered down, and as a result also all the human rights protection system as we know it is at a crossroads. There are some inherent challenges related with the use of open data from social media in general, and these challenges derive from the input of the data as well as from the way these data are being processed. With regards to the input, we can see, first of all, that there are consequences related with the self-selecting nature of social media users. This is also reflected in the quality of the data that are available on social media. Furthermore, there are inequalities in accessing social media platforms and data. Well, as we know, social media is used globally. So when thinking about inequalities, one does not need to think only about Europe as a geographical area, but worldwide. And thirdly, there are difficulties for users of social media to understand the differences between what is public and what is a private space in these platforms. Often, social media users think that they are sharing their ideas or pictures just with their friends because they have only those limited connections, and they have not realized that they have not been placing proper privacy filters in their accounts. With regards to the processing of data, there are other problems. First of all, it is difficult to obtain a meaning from the heterogeneous data that have a very variable quality and provenience. Often it is difficult to observe and interpret this data because the context and the background in which the data have been published is not necessarily available to the researcher when processing this data. And there are also some potential limitations with regards to the way in which open data from social media are made available by the social media platforms themselves. It's often unclear if at a specific point of time, all the data are made available, or the algorithm of the social media itself already makes a pre-selection. These challenges can further translate into ethical and human rights concerns for individuals and data subjects. Firstly, individuals are just given a digital identity and are used as sources of data. So their autonomy and dignity is not really safeguarded because of the self-selecting nature of social media users, and because not everybody uses social media. There is the possibility that when processing the data, certain biases and discrimination comes in place, which can bring very easily to the creation of stereotypes and further into chilling effects in the society. If one knows that his data are being used for specific purposes, next time might think twice if continuing to express his opinions in the way he would have been doing this if he knew that the data would not be processed. And last but not least, there are no effective safeguards with regards to the data subject rights. And when I'm saying this, I'm thinking about those rights of erasure, right of changing your mind, are not taken into account when processing the open source data, because the data are being harvested at a specific point in time, and whatever the content was at that specific point of time, it is being analyzed. So if somebody was afterwards erasing his comment or the picture or changing the opinion, this is not taken into account. With regards to the rights to privacy and data protection, what we see with regards to open source data from social media is that there are two assumptions that researchers and processors of personal data are always bringing forward when processing this data. And both assumptions are actually wrong. The first assumption is that whomever publishes data online without any privacy filters does not have any privacy expectations, so no need to worry about the protection of the right to privacy of these social media users. However, there is case law from the European Court of Human Rights that is not applicable directly to the digital world, but it takes place in the physical world, like, for example, PJ&JH against the UK, in which the Court of Human Rights has established that also in public spaces, an individual has a right to privacy in those instances in which we have a systematic or permanent data recording, as it will be the case with open data from social media. Furthermore, in other case law, like in Perry against the UK, the Court of Human Rights has established that if technology is being used in instances that are not really foreseeable by the individual, then the individual should enjoy a right to privacy, an expectation of privacy. And this would, of course, be the case when we harvest data from social media. Individuals, social media users, do not necessarily know or expect that their data are being processed for other purposes. The second assumption, the second wrong assumption, is linked with the right to data protection. The researchers that analyze data from social media are starting from the assumption that because the data have been made manifestly public, there is no need to worry about the other safeguards that the GDPR offers to data subjects. And they link this with Article 9, second paragraph E of the GDPR about open data that are manifestly made public and are of a sensitive nature. However, the EDPS has been clearly stating in its opinion regarding the use of open source data for research purposes that any use of this type of data should be considered in a restrictive way and always in conjunction with Article 6 of the GDPR. So one needs to think of a lawful legal ground for processing the data. And clearly consent is not such a legal ground in these cases, because whomever publishes the data online is not giving consent for having this data used for whatever purposes. Because the data are now used a lot in training algorithms and artificial intelligence, it is interesting to see if the draft Artificial Intelligence Act is referring to open data from social media as well. And what we notice is that there is no specific mentioning about Web 2.0 open data in the Artificial Intelligence Act as well. As it was mentioned a number of times yesterday as well, the Act is qualifying artificial intelligence on the basis of risk levels into three main categories, which are mainly related with the output of the technology. However, inherent problems of the output are created by the data that are being used for training the algorithms. And in these regards, with regards to high-risk artificial intelligence, the Act mentions that high-quality data sets should be used for feeding the system in order to minimize any discriminatory outcomes. However, keeping in mind the inherent problems that we have with Web 2.0 open data, a conclusion can be reached that these data do not fulfill the requirement for high-quality data sets. And furthermore, they would not fulfill the transparency requirement that was introduced last June by the Court of Justice of the European Union in the decision about keeping in life the passenger's name recording directive. What can be done regarding open source data from social media? What we see at the moment is that we lack regulation regarding this data, and we see that this data can create a lot of problems regarding the protection of the human rights of the individuals. There are three possible ways to go about the regulation of this data. We can have a minimum intervention, a medium one, or a maximum one. A minimum intervention would mean to just apply the laws as we have them in a restrictive way. For example, once the Artificial Intelligence Act enters into force, because open data from social media do not fulfill the requirement of high quality databases, then in implementing this law, in enforcing this law, we can have the result that this data should not be used for training high-risk artificial intelligence, or maybe also artificial intelligence in general. However, seeing how things are going at the moment, this is going to be very difficult, because the use of this data is now very crucial for training algorithm, and we have already an established use of this type of data. Thus, it will be difficult to just stop using open source data from social media for these purposes. Well, the second possibility, a medium intervention, would be to recognize the risk and characteristics of Web 2.0 open data, and to think of possible interventions by the courts, in some laws or policy interventions that recognize those risks. We will, however, have a potential risk of having a very fragmented system that will again operate in the detriment of the protection of the rights of individuals, and go in favor of continuing to use open source made data from social media in general. The third, and which personally I think is the most plausible possibility for intervention, would be to have a maximum intervention, to introduce new laws regarding Web 2.0 open data in general, but also regarding their use and limitations with regards to artificial intelligence. This is an ongoing research, which, of course, it's all to be seen in the future. I therefore conclude here, and thank you very much for your attention, and I'm looking forward to your questions and comments in the discussion session. Thank you.
Thank you. Thank you very much. Thank you very much, Ionida. And thank you also for the clear presentation. And now we are collecting some comments. I see that some comments arrived. And now we start with the second presentation, and we will keep the discussion at the end of the first part. So I asked to Emanuele Brambilla to start to talk about his research lines and the core of this paper, and then first to keep 1 minute of the presentation to present himself and the actual research lines. Please, Emanuele, and thank you very much.
Thank you. I am Emanuele Brambilla. I am a PhD student in philosophy of law in the Department of Law at the University of Milan. The guidelines of my studies are artificial intelligence, human dignity, anthropology, privacy, and 3 of them, such as privacy, anthropology, and human dignity, are also in this extended abstract. So
great. Thank you very much. If you've got some slides to share with us, you can upload them directly on the StreamYard system, and we will show. Perfect. Thank you.
Thank you. Thank you. So the term privacy evolved thanks to the internet and to the development of the digital society. So nowadays, privacy can also refer to our data on the web. These data on the web are less controllable and vulnerable, since they are scattered on different devices and different platforms. And maybe we don't really know where they are. So regulations are helpful to prevent harm or to adjust negative consequences. The GDPR has, as Professor Sartor points out, a double and a synergetic approach. So these two approaches are not opposite, but they work together. The first approach is a right approach. And this approach is represented by data minimization and pseudonymization, for example. The risk approach is represented by data protection by default and data protection by design. The point of connection between these two approaches is that risk does not automatically entail that our data are unsafe, but that they are safeguarded, or that they should be safeguarded, even if entered on digital devices, web platforms, etc. This brings us to the problem of the different shades of privacy. The first shade of privacy is data protection. For example, the GDPR in Article 25 does not say privacy by default design, but it literally say data protection by default and data protection by design. So we interpret privacy as the protection of data, and this is a first and basic level. A second level of privacy is data control. So the control, the govern, and the right to follow our data where they are. We should know who owns them, who have them, on what platforms they are, and maybe who are the third parties who owns them. The third shade of privacy is the digital body. So this concept has been introduced in Italy by Professor Rodotà, and it can have different interpretation, as we will see later. For now, we can say that digital body can be considered as all our information on the web. Floridi, in this regard, Professor Floridi, in this regard, says that the protection of data is not a mere problem of privacy, but it is also, and in particular, a problem of protection of individual identity, of personal identity. This brings us to a question. So what kind of relation then there is between us and our information? Floridi says that nowadays there is a strong gluing between our personal data and our individual identity, since our data can reveal in a very easy way our personal identity, and this can bring us to harm for our identity. However, we have to understand what the term identify means in this context. There are two interpretations in Floridi. A first interpretation can be found in a 1999 article called The Ontological Interpretation of Informational Privacy. And a more recent approach of Floridi is from the book Il Verde e il Blu of 2020. And in this book, it seems to lean towards a more relational interpretation. So, the ontological interpretation of Floridi is that we are our information. So, then our nature, it says, is composed by our information. In my extended abstract, I suggested that we should divide data in intrinsic and extrinsic. Extrinsic data are, for example, our address or our cell phone number, our credit card number, our car plate. Our intrinsic data are, for example, our name, our surname, our physical description, our personality traits. And I said this because if we overlay our personal identity and our digital body, there will always be something that exceeds. They cannot be ontologically and tautologically compared, in my opinion. So the digital body, and these are the different interpretation, the digital body can be considered as a mere sum of information, of extrinsic and intrinsic information. On the other hand, there are people who says that the digital body is not a mere sum of information, since from certain data of the digital body can be inferred something else. So, for example, if we know that a certain individual watches certain kinds of movies, horror movies, or thriller movies, we can infer something on his personality that is not included in the digital body. On the other hand, we can say that, yes, the digital body is a mere sum, and thanks to, as Aristotle would say, a syllogism with premises, we can infer the conclusion that is implicit in the digital body. The other interpretation is the relational interpretation. Floridi in Il Verde Blu says that we are also set of information and not only set of information in an informative relation between digital devices and other people. So there are different sides of these relations. The first side is between us, people, and digital devices. The other side is between us and our information, as I have said before. When we are speaking directly to a person, I believe that, yes, we are exchanging information, but this fact is not really relevant for the conversation, for the conversation. On the other hand, when we are in front of a computer, there is, yes, an informative relation, because we put data on the computer and the computer gives us information and data. On the other hand, there is a more anthropological problem, because even if our society, the digital society, as Floridi calls it, gives us more relational possibilities, on the other hand, as we are right now, we are in front of a screen, but we are alone in front of a screen. We are not really together. And I'm not saying that we cannot use computers. We should use computers, but on the other hand, we should recover a true dimension of relation, and we should take what is comfortable on computers. So, and for what regards the relation between us and our information, we should, yes, equate the protection of privacy as the protection of individual identity, extrinsic and intrinsic identity, but we should not ontologically equate the person to the digital body, because I believe that it is not a tautology. This brings us to the behavior that we should have in front of computers and others. We should have more responsibilities and more accountability. And we have to give computers the correct value, their correct value. And we should recover the true dimension of the self. This brings us to the problem of dignity, to the question of dignity, to human dignity, which, as you can see in the title of the slide, is a cornerstone of my argument. In the GDPR, dignity is mentioned once in Article 88, which is called processing in the context of employment. So it is a very specific article, and dignity is not mentioned as a basic premise. So now we have to understand what dignity means and what are the different philosophical theories of dignity. There are two main theories of dignity. The first is the theory of performance. The second is the theory of ontological dignity. I believe that the first theory is not acceptable, since it grants dignity only to people who actively, and this is a very important term for this theory, actively show certain capacities, certain rational capacities, or certain functions. If we follow that, it derives that children, for example, of small age, or people with disabilities, have not dignity, and this is unacceptable. On the other hand, the theory of ontological dignity grants dignity to all human beings, since it bases dignity on human nature. So human nature has inside it rationality in potency, and it doesn't matter if someone would not show rational activities, for example, when he is sleeping or when someone is in a vegetative state. It does not matter. It always has dignity, since dignity it is based on human nature. Another way to assess this is that we are a persona. The word in Italian is more maybe profound than the term in English. So we are a person, and it's a very important philosophical term that we have to distinguish from individual. However, there is a point of connection between the two theories. So there is this. We have ontological dignity founded upon human nature, and this dignity is not assigned by other people, but it must be recognized by other people and by the law. So we recognize it. We can recognize something that there is, not something that we assign. And it is a very important difference between the two theories. On this topic, Floridi says that always in Verde Blue, that we should not accept for, as he says, anthropological exceptionalism, but we should place dignity on our fragility, and as he literally says, on our being the beautiful glitch of the universe. Among these four anthropological exceptionalism are the Greek one, the philosophical Greek one, the second is the Catholic one, the third is the modern one, and the last is the contemporary one. I centered my paper on the second one, and on this second one, Floridi says that it is for him irrelevant for nowadays society, but I don't believe that this is true, because, for example, in nowadays society, we can still use this, we can still care about this. So the concept of dignity of Thomas Aquinas, for example, is the concept of dignity that I have explained before as the theory of ontological dignity. So dignity, it is based upon human nature, on being a person, on having rational capacities, for example, in potency. And they are in potency, and even if they do not show in act, even if we don't manifest them, this does not matter, because we have them in potency. We have the ability to do that. So this brings us to the last question, is the question of the dignity of the human body. So the dignity of the human body can be inferred thanks to the dignity of the human person. The human person has dignity, so also her or his data has dignity and must be protected. And I believe that the digital body must be protected in a more profound way than single data, because it can be processed in more ways than single data.
Perfect. Thank you very much, Emanuele. I'm noting down some questions that arrived regarding your talk, and we will discuss later at the end of the first slot in the morning. Thank you very much. It was very clear and very interesting.
Thank you.
So the last presentation of the first part of the morning is from Urbano Reviglio and Giulio Santoni, and the title of the research is Governing Platform Recommender Systems in Europe, Insights from China. I see that if you want to share a presentation, you can upload now on the system. And I will ask also to you the first minute of your talk to describe your research activities and your work and also your actual research lines. Yes, I see the slides. So please, thank you very much. Urbano, we cannot hear you. We cannot hear your audio. Yes, I hear something now. Try to talk. Giulio, can you try to talk also? See if it's a problem of Urbano or.
Yes, can you hear me?
Yes, Giulio, we can hear you very well, but Urbano has no audio now. If Urbano, if you want to try to reconnect, or there's no problem. We've got time, so let's try to fix this technical problem. I don't know, Giulio, do you want to start to explain your work, or we wait a bit to see if Urbano can reconnect and start him? Let's see. Okay, Urbano, try to talk. No, we cannot hear you, Urbano. I'm really sorry, but there is no audio from your computer. We can, if you prefer, Giulio and Urbano, I can switch and ask to Emilio, for example, to give his presentation in the last part of the morning, and then try in the second part of the morning if you fix your technical problems, because we really would love to hear you both in your in this. It's okay for you. Okay, so I will let's switch your talk, and I kindly ask to Emilio Sacchi that I put on the streaming now. Okay, thank you, Emilio, and
You're welcome.
To explain your idea of metaverse and metacrimes and new threats for people. You don't have to have a PowerPoint presentation, right? You talk,
no, I don't.
Okay, so please let's give us the idea of your research lines and also a short presentation about your
Okay.
Please.
Welcome everybody. Good morning. I'm very pleased to be here with you and to have a chance to talk about my line of research, which regard metaverse and what I call metacrimes, so crime committed or perpetrated in a metaverse environment. My name is Emilio Sacchi. I'm a criminal lawyer, and in the past few years, I focused my work and my line of study on cybercrime and cybersecurity. That's the reason why, when I got the chance, I focused my study on metaverse and metacrime. I think that this is an important matter because in a few years from now, we may have an opportunity to spend a part of our time, of our daily time, in a metaverse. I say this because due to a research made from Gartner Incorporated, by the 2026, at least 25% of the people of the world will spend 1 hour and a half in a metaverse environment. This is important data, this is important information that can lead us to some thoughts. First of all, it's important to understand what is a metaverse, because usually, because metaverse nowadays it's a common word used by many people, but I'm not so sure that anyone could understand exactly what a metaverse is. Let's start from the beginning. The first who used the word metaverse was Neil Stevenson in his cyberbook novel called The Snow Crash in 1992. And then from a few decades, nobody talked about it anymore until Facebook changed its name in Meta, and then the word metaverse is being used very commonly. To start to understand what is a metaverse, I start from the definition made by the Treccani Encyclopedia, one of the most important Italian encyclopedia, which says, and I read it, that a metaverse is a three-dimensional space where people can move, share, and interact through avatars. I think it is a very clean definition of a metaverse and is useful to understand that we don't have only big platform, big metaverses, but we may have also small one. When we talk about metaverse, we think about the Decentraland, Euroverse, Sandbox, OVR, the Italian metaverse, and so on. So big platforms with many users and basically on blockchain. But if we focus our research on the definition I said before, we may understand that we may find the metaverse environment also in small virtual private room, because in those kind of spaces developed by many companies, we can share our thoughts and our body movement in a small environment, like a private virtual room, where we can attend meeting, a conference, and so on. So if we understand that metaverse is not something made by nerds for nerds, something made only to entertain, but if we think about metaverse like something we can be a part of, we can work in, we may understand how it's important to make it a safer possible place. I'm frightened that metaverse will have no regulation like internet has in the first place, social media follow, and so on. So usually law is always very far from the technology, and nowadays we have a chance to make some strictly regulation of a metaverse. I know it's a long shot. I know that nowadays metaverse are quite empty. I know that many big company step back from developing a metaverse right away because there's recent news about what happened to Meta, what thought about Microsoft, and so on. But I think it is an eventually, and if it eventually may happen, we may be prepared. The other another point of view that we may have very clear is that most of the people that will use metaverse will be likely minors, so we need to have a safe environment. Why I say about safe environment? I talk about safe environment because it already happened that a crime is committed into a metaverse. I do not mean to speak about using a metaverse like a tool, I mean to speak about a crime committed actually in the metaverse. It's what happened in the May 2022 to Nina Jane Patel, a journalist that was having a trial of a metaverse called Horizon World, and during this trial, she suffered a sexual harassment made by other avatar to hers. This is a very bad situation. This is a very scary situation because, as happened before, people think that in internet, in Web 3.0, there are no, and this is a myth that we have to stop because it's very important. That Nina Gempel was so deeply connected due to the virtual reality, the immersion of virtual reality, that she suffered like she was living that bad event in herself. So, starting from this point, what happened? It happened that Meta was forced to introduce a protective bubble that prevent anyone from interacting with the avatar who activated. I think that this can be a solution, but it cannot resolve the problem of MetaCrime because this bubble is right that prevents any avatar to interact with the avatar who activated, but also prevent the avatar from interacting with all the metaverse. So with all the future, so the avatar is quite in a freeze situation, and he or she can do anything. And I think this is not a solution, because to have a solution, we may have the possibility to make people enjoy metaverse without being scared of being a target of crime. Speaking of crimes, during my study, I focused my work on three types of crime I think it may be committed in a metaverse environment. The first type of crime is a crime that produces effect only in the virtual world. The second type of crime is a crime that produces effect both in the real world and in the virtual one. And the third type of crime is a crime that produces effect only in the real world. Starting from the last one, which is also the easiest one, I think that we can think about the metaverse like a tool. Because if I use my avatar to commit a crime and to target the victim is the owner of another avatar, I use the metaverse just like a tool. For example, if I meet with my avatar, Professor Ziccardi Swan, and acknowledging that that avatar is owned by Professor Ziccardi, I say to him, hi, Professor Ziccardi, I know who you are, I know what you've done before, and I will make you pay for it. So it's a threat. It's a threat that I committed using Metaverse just like a tool. I could use an email, I could use a post on a social network, I could use many other tools, and I choose to use a metaverse environment. So it's just like a tool. And for this kind of crime, we can say that, for example, Italian law is already prepared for it, because it can work with it like he pursue any other cyber crimes. The second type of crime I find out is a crime that can produce a double effect, an effect in the real world and an effect in the virtual one. For example, a fraud committed in a meta environment, so in a metaverse, regarding selling fake NFTs may be a crime that produces a double effect, because on one hand, the owner of the buyer, we can say, so the owner of the avatar who bought the fake NFT suffer a loss of money, because he or she lost his money, the money that he used to buy crypto, used again to buy the fake NFT. And on the other hand, the avatar is incapable of using the fake NFT in a virtual environment because it doesn't exist, or is not real, so is not original, and so it cannot be used because of these forgeries. And the third type of crime, which is also the hardest to be regulated, is a crime that produces effect only in the virtual world. For example, we can say that a cyber stalking or a threat from an avatar to another avatar. So the difference between the first case is that in the first case, I use my avatar to threat the owner of the other avatar. In this case, I use my avatar to threat the other avatar, to make him can be perpetrated and only in the metaverse, and that have no real world effect. This is a very strange, we can say, situation, but I think it's important to have it regulated, because we cannot allow like a behavior in a real one. Coming to the third part and the last part of my abstract of my research is how to prevent and pursue author of crimes. I think that to prevent a crime, we need a multi-level security system that can be developed using the AI, and the AI can be used to recognize, can be trained to recognize action, word and wording that can be that can be actually a crime. And after this training, the AI can let the victim or the target of a possible criminal action to freeze the author, to record what happening, so to record the screen and to submit what happened to a moderator, or to request an immediate assistance for what was happening. Given that, starting to understand how to prevent eventually a crime, we need to focus on how to pursue the author of a crime. And for this topic, we have two major problems. The first problem is to recognize the author of a crime, and the second problem is to identify it. Then we have another problem, is to punish it. So for this kind of problem, I thought about a solution which may be a private blockchain where everyone needs to be registered, and this private blockchain can be used to like a central authority. We can think about an independent authority for Europe, an independent authority for US, and so on. So a central authority that will give to anyone who apply a couple of asymmetrical keys used also both to log into any metaverse and to control the wallet of the crypto, for the crypto trading and for the NFTs trading. In this way, on one hand, we have the possibility to identify the author of a certain crime, because the avatar, that particular avatar, is linked to a unique public key. So we may know, we have the possibility to know who is the author, who is the owner of the particular avatar, and then we may punish the author of the crime. But how? I thought about it and I came up with this solution. Due to the particular type of metacrime, I think it's important to have a double effect also as a punishment. So we may have a punishment in the real life, which we already have. So it's a jail time or a money punishment and so on. And on the other hand, we may have a virtual punishment that may affect the avatar. So we may use this virtual punishment to prevent that avatar, and that avatar, which is the only avatar that the owner can create, to do to make new crimes, to make new bad action. And I thought about two type of punishment, and so to convert eventually jail time to a ban time, and to convert to apply monetary punishment to crypto assets. To do so, we can use the power of a private blockchain, because in a private blockchain we will be able to ban a private key from logging, prevent a private key from logging into any metaverse through a bridge for a certain amount of time. It can be 1 hour, 1 day, 1 month, 1 year. And then we can also use the power of a private blockchain to prevent any payment in or out a certain wallet. In this way, we may have some tools that can help us to have metaverse a more regulated environment. I know that with my speech, with all those my theories, I raise more answer that I raise more question than the answer I produce. But I think that to find out a solution to a problem, we need to make many questions, and only good question can lead us to a good solution. Thank you for your time, and I'm here to any of your questions.
Okay, thank you, Emilio. Also, thank you for the kindness to anticipate your talk. Then I call on the board of our software, also Ionida and Emanuele. We will add to the streaming all the speakers of the first part. And I've got some questions for you that we received also from other fellows of the center. We've got exactly 30 minutes because we are planning to end this first section at around 10:30, but we started a bit late. So I will give 10 minutes more to each one of the speakers, starting from Ionida, and I will summarize the two most important questions I think that were included in the questions coming from the public. Ionida, I would like to ask you about the fairness principle and the importance, in your opinion, of the fairness principle of processing of data, especially from a data subject point of view in your research, and then the problem of the power and the business of the platform. So if you think that your research could be influenced also by the, how to say, the actual business and power of the platforms, that it's a very important legal problem. I kindly ask you to be very, very quick in your response, but I think that these are two very important points. Thank you.
Thank you very much, Professor. Two very interesting questions, and I would consider them also as suggestions, especially with regards to the principle of fairness, which is indeed very important, also with regards to analyzing and understanding the ethical complexities of the use of open source data from social media. And the principle goes, of course, in parallel with other human rights and ethical concerns, as, for example, with regards to the autonomy, dignity of data subjects, non-discrimination, etc. And it is very important. And I will indeed elaborate more, like I'm taking it more as a comment than as a question, and I'm going to elaborate more regarding this principle when I prepare the full study. Your second question regarding the powers of platforms and their business model with regards to making open data available is also a very interesting one. Well, currently the law on artificial intelligence is not yet in force, but what we see, what is the tendency of the legislator in this law, is to, in a way, while allowing artificial intelligence technologies to develop, also to ensure that the rights of individuals are being protected. And in this framework, we have the category of high-risk artificial intelligence that might create problems and risks regarding discrimination and the protection of the rights of individuals. In that regard, it was also my point and conclusion, in a way, regarding open source data from social media, that they do not really provide an high quality data set because of those inherent problems that are in data from social media themselves. And if we would see this in combination also with the decision of the Court of Justice of the European Union regarding the passenger name records directive, when it was establishing that if you cannot be transparent, then an artificial intelligence system at the border should not be used. That makes it immediately more complicated, the story, because if we would think about migration and border control, and this is also a little bit the point of view from where I was originally coming, there are already existing databases that are being used for creating the risk analysis and gathering intelligence. You have available databases from the Eurodac system, from the Schengen system, from VIS1 and 2 system. And there the data are already collected in a way for individuals and are to a certain level verified. However, when in parallel you use open source data from social media in order to validate these systems, one has to keep in mind that these data have problems that are inherent in the database itself. If we are just thinking about the countries of origin of migration, not everyone has access to social media. This can be also already a distinction between males and females, between living in poorer parts of the country and in richer parts of the country. However, there is a certain group of people who are migrating. So using this data that come from a big pot of individuals that maybe are not even thinking of migrating, and then connecting this to potential migrants, the system is already presenting inherent risks, possibilities for discrimination, and clear problems regarding transparency. Would this change the business model of social media providers? That is a very interesting question. Most likely already the adoption of the Data Act would change the business model, because in the Data Act, data subjects will have a right themselves to decide about sharing their data. What is important in my point of view and in my research is really recognizing the problems that these data provide. At the moment, we are in a way ignoring the effects that the use of this data is having for the protection of the rights of the individuals. The first step would be to recognize these problems and then to see how we can address them in order to ensure that the human rights of the individuals are being protected. Is this too much power for the platforms? I don't think it is too much power for the platforms because the data are open. So in principle, everybody can access this data because they are without any privacy filters. The point of view of the European Data Protection Supervisor regarding the case-to-case analysis is more referring to researchers and the ones that will make use of this data. So they say, well, you can use this data, but you have to make sure that the social media provider wanted this data to be used. And this is then a responsibility for the one who uses the data. In principle, the social media platform has the data open already and everybody can access this data even without this contract in which you harvest all the available data. So I hope this answers the question to a certain extent.
Yes, it's very clear. I think that these are a sort of, how to say, also inside the problems of the system, because in the last 20 years, as you probably know, especially in Europe, platforms gained a level of power that is very difficult to deal with today, because it's strictly connected to the beginning of digital economy in the European Union. So we left a lot of freedom, also business freedom, to platforms, and today it's very difficult to regulate it. So Yonida, thank you very much. It was really a pleasure and an honor to have your talk. We are looking forward to read your final work that we would be very glad to publish in the proceedings of the conference. We are planning to keep open access, of course, the proceedings of the conference, to try to disseminate your work and also to raise new comments and new consideration. Thank you very much, and have a good day, and thank you.
Thank you. The pleasure was all mine.
Bye-bye. So, Emanuele, thank you very much also for your presentation. I see 2 points in the questions that we received about your paper. The first point is if you think it could be possible to better elaborate a connection between the origins of privacy and the idea of privacy and human dignity. And the second one is, in your opinion, the importance of the understanding of self and the mediation of a real understanding of self through digital devices, and the fear to lose the dimension of the understanding of self. Are these 2 points, in your opinion, that you are planning to deal with in your research, and you think that they could be important? And can you explain in 10 minutes, please, your opinion about these 2 comments? Thank you.
Thank you. Thank you for your questions. I take them not only as questions, but also as comments and research lines, because I believe that I can think about them more and use these devices. I can interpret them as devices too, and use them for my thesis and for my work. So I think that the connection between privacy and dignity should be more elaborated more, and I'm talking about myself. I should elaborate it more in the future. So I should say this, that violating privacy in certain cases can be a violation of dignity, but I don't have now a practical connection, a practical answer. I have more a theoretical answer. And what I said is this: we should use in my opinion, of course, the ontological dignity as a base, and then from this base, we can understand, for example, privacy violation, certain privacy violation. For example, if we put cameras in a supermarket and the cameras work 24 hours per day, 24 hours per 7 days, and this camera watches workers every time and whatever they do, I don't think that it is I think that this is a violation of workers' dignity, for example, and is an example of a connection, maybe a practical connection. But I think that these studies can be elaborated more. So I have not a perfect and clear answer. The answer should be developed, and I will develop a complete answer in the future in my research. So for what regards the connection between computers and the self, I said that in the extended abstract, we should treat computers not as goals, but as means, because I see a danger in an overpower of computer. I'm not talking about the singularity of Kurzweil. I'm not talking about this, but I'm talking about the recovering of the dimension of the self that should be taught, maybe in some areas, not as computerized. So we should think about computers as useful means, comfortable means that help us, but not as goals. And I think this is the answer of the third question. Moreover, we should, for example, maybe divide dignity and specify dignity in this way, maybe in regards to Directive 680 of 2016, for example, because one maybe can object this. If the human have dignity, we should not control him, even if he's a suspected criminal or is a real criminal. But we can say, for example, let's do a theoretical example. If he is a criminal, for example, a real criminal, we know that a certain person is a criminal. Directive 680 permits a control of the data of this person, but this is not against dignity, because we should divide dignity in ontological dignity, and ontological dignity can never be lost, as I said, can never be lost. But moral dignity can be lost if the person, for example, is a convicted criminal, or we know for sure, so it is not a practical example, this is a theoretical example, we know that he is a criminal. But we must not control him in a way that attack his ontological dignity. So ontological dignity must be respected in every case. I don't know if I have answered to the question. They're very difficult questions.
Yes,
so.
Yes, I think it's very interesting, because there is the need of a sort of interdisciplinary approach that involves several point of views and several aspects that are in conflict between them in many cases, because the idea of the use of digital devices also to better understand the dignity but also the self of the person is very important, but it's also changing year after year, in my opinion, in a way that it's very faster than the law, and how can the actual law can regulate this topic. So it's very, no, I totally agree. Thank you very much, Emanuele. We wait your final paper for our proceedings, and you will have more pages and time to better explain your ideas. And
Thank
good
you for
luck
the
for
opportunity.
good luck for your work and your PhD and your research activity.
Thank you. Thank you very much. Goodbye.
Thank you. So the last small debate of the morning is about the research of Emilio. Emilio, I've got a couple of questions coming from fellows of the center, and one question coming from Professor Perry. The fellows are interested about your opinion concerning the possibility of the intervention of international monetary institutions in the regulation of the metaverse. And so the idea of the follow the money or control the money regarding this, that it's a typical criminal approach. And then the use of metaverse for information warfare and also circulation of critical information. And then Pierluigi Perry is asking if the present legal tools are enough to combat crime on metaverse, or if there is the need for an international protocol considering the mixed reality typical of the metaverse. So you've got 10 minutes also for you to explain the points.
Thank you, Professor. Thank you for the question. For the first question is it's we have a the local 5 meta because typical metaverse environment, which is blockchain based, we have many problems to, as I mentioned before, to identify criminals and to pursue criminals. And so I think we need to aim for international authority that can work together with already existing international authority like European Central Bank and International Monetary Fund. If also we have a new crypto, a new asset that is controlled and that can be investigated on in a new way because it came from a central authority, it would be easier to follow, as you mentioned before, follow the money, follow the lead, the traces that the money leads, in order to identify and punish the author of international crimes. Because another important matter in a metaverse environment that is that let people connect in a deeply way from all over the world. So we have the problem of legislation and international laws, because it may happen that a kind of action in Italy is legal and in another country is illegal. So it's clear that we cannot have one international, one metaverse regulation for each country in the world. We aim for a central authority, even if metaverse came from Web 3.0, so to the central environment came from a blockchain, use crypto, use NFT. So goes on the way of the central work, the central DeFi and so on, the apps and so on. But we need a central authority because we need one law, we need one regulation, we need an international agreement that can be followed to pursue the certain crimes. Otherwise, we have no power. And connecting this to the Professor Sperry question, nowadays we have no power to pursue a metacrime. I think that the only possibility to pursue metacrime is if we think about metaverse, as I mentioned before, like a tool, the third type of crime identify. So use a metaverse just like a tool and not in its full potential. If I, as the example I made, I threat one avatar for another one's avatar's owner. So when I mentioned your avatar and I threaten you, so for that kind of crime, we have the tools. But for a real, we can say, metaverse crime that can be committed in the metaverse and produces effect only in the metaverse, nowadays we haven't the tools. We haven't neither the regulation tool nor the technical tool to pursue and to punish an author of crime, because we need a deep investigation to understand who did what, who's the owner, if the avatar is controlled by more than one person, who will pursue, who we will punish, because it's a huge problem. So I think that nowadays we are in an early stage, but due to the fact that also Metaverse is in an early stage, because we know that Metaverse are not so crowded nowadays, I think we have time to prepare ourselves, to prepare the state, to prepare the international authority to step into Metaverse with a strong regulation, with a strong law. And answering to the second question, I think that it will be a key for information warfare, the Metaverse, like are the we can say the chat nowadays on deep web, like other tools to communicate that let people very far away to communicate. The Metaverse will be also a part of information warfare. And how we can prevent it, I think we need to use an AI to flag some kind of word or some kind of wording, some kind of phrases that can be muted by the artificial intelligence, or that can flag the author of that kind of word, the kind of sentence, and make an investigation on it to understand if it's a sporadical and one-of-time sentence or if it's using Metaverse to pursue some kind of ethical crime or radical or hateful agenda.
Perfect, Emilio. You were really clear, and I totally agree that the idea of international legislation or international actions is very interesting from an abstract point of view. But of course, internet and the metaverse are changing every day, so it's also very difficult to understand the borders or where there are no borders. So I really would like to thank Ionida, Emanuele, and Emilio. We are also in perfect timing because it's 10:30. It's not easy in such important conferences and with a lot of debate. So thank you very much. And now we will start the second part of the morning, when we will hear the description of research lines from Guillermo Peixote Migliora, Sinem Ozigit, and Urbano Reviglio and Giulio Santoni, that I'm keeping them in the last part of the morning because they are having some connection problems, and it's in the game because we will have 3 days of connection, so it's normal that there are some problems. So we will try to connect with them at the final part of the morning. I ask to now to Guillermo to join me in the streaming. The title of this very important study is regarding the important relationships between freedom of expression, rights of the victims, and online hate speech. So, Guillermo, thank you very much for your proposal and for your work. I will ask you to use your first 2 minutes of your presentation to describe your activity and your actual and future research lines. And then you will have 20 minutes to summarize the most important part of your work. In the meantime, I will collect some questions for you coming from the fellows and from the audience. And at the end of the presentation of the 3 papers, we will also have another part to debate. Thank you very much.
Thank you, Giovanni. Oh, I see that my slides are up. Well, I'm a PhD candidate at Leiden University, and this is a research that I started as my master thesis also here at Leiden University, and now I'm continuing as my PhD thesis. The topic that I'll be discussing is how the prevalence of freedom of expression over the rights of the victims might be influencing the way we tackle hate speech. Here is a brief overview of the presentation. I'll start with a little bit the discussion between online hate speech and freedom of expression and how that prevalence works. Then we'll go into a more theoretical part of the presentation with the definition of hate speech. Then we will dive more specifically into the rights of the victims. And then I'll try to present the beginnings of what I think can be a solution in the discussion of the principle of functionality and how it applies to platforms. And then we have some brief conclusions and some questions that I intend to discuss further in my thesis. Well, diving right into it, when we talk about online hate speech and freedom of expression, and the prevalence that freedom of expression has in the regulation of online hate speech. And just to keep in mind here, we're talking about the way that online platforms regulate online hate speech. We can see that this prevalence of freedom of expression exists mainly due to a double incentive, right? So the first issue that needs to be highlighted here is that most of those companies come from the US legal culture, which has a very permissive approach to speech. So you have regional, national law and case law that has been allowing what I would consider harmful speech for a really long time. And this ends up being ingrained into the way that platforms function. And I think that's even true to those platforms that are not, that came a little bit after and are not incorporated in the United States. But those first platforms that were incorporated into the United States, they kind of like set the rules and the way that things work for the platform. So then you have this first influence of the US legal culture kind of putting freedom of expression as the sole tool or ahead of other tools. Then we had what I think it's the most important part in this slide, which are the business incentives that platforms have to prefer freedom of expression, right? And then you have the first element, which is the more content they have generated in their platforms, the more ways they have to generate profit. So more content equal more profit. And then you go to the question that several reports and articles have been pointing out in the last few years, that even though there's some discussion about that, but that controversial content generates more engagement, right? So then you would have a situation where the platforms would have both a quantitative stimulus to put more content and also a stimulus to put controversial content or content that is harmful or content that it's a borderline or kind of like could or could not cause harm. So then that's where this prevalence can come from. I think it's important to understand that despite that I'm saying here that there is a prevalence of hate speech on the way that online platforms a prevalence of freedom of expression on the way platforms regulate hate speech. It doesn't mean that I'm diminishing the importance of freedom of expression and that I'm contesting the importance of that right. Well, then in this situation, right, when we're faced with this situation where freedom of expression has a prevalent place in the regulation, you end up with a scenario where other fundamental rights are either left out or marginalized in the self-regulatory frameworks of platforms. And that means that those companies do not have in their regulatory frameworks the legal obligations to abide by those rules, and also it means that it's more difficult for users to use those rights as tools to reclaim their rights. And here is just a quick example. This is a screenshot of Facebook's of Meta's policy on hate speech, and here you see a list that is very narrow on what is prohibited to post. And I couldn't fit everything into the slide, but if you see the rest of the list, you guys can see that there are several types of speech that I personally think we should consider harmful, that are not tackled by Meta. And also there is no express mention to any other fundamental rights that not the right to freedom of expression. So this is an example of how this prevalence kind of materialized in a more concrete way. And then the problem with all this situation, and I think that might be one of the most important takeaways from this abstract and from this early stages of my research, is that we might be looking into a situation that we won't be able to change that reality that we've seen in the first slides if we do not tackle online platforms business model, right? Because while they have this incentive to generate more content and to generate controversial content, it might be impossible to properly address questions as hate speech, fake news, deep fakes, and some other problems regarding content moderation. Well, but then I think that the first step, at least in my research, to kind of trying to find a solution to that problem, specifically to when we talk about hate speech, is to properly define hate speech, because I think with a definition of hate speech, with a good definition, we can give more protection to the victims and kind of rebalance a little bit the victims' rights that have been relegated so far, and freedom of expression. And the basis for my definition will be this definition that was given by Mari Matsuda in the book Words That Wound. This definition was given in a context where she was defining racist speech. So I'll tweak a little bit this definition, but just to go into a little bit, this definition has three elements. The first of all is that it needs to be a message that conveys racial inferiority. Then the second element, it needs to be targeted at a historically oppressed group. And then it needs to have an intent to be persecutory, right? And in my research, I found that those elements wouldn't be enough to address hate speech and online hate speech today. So I'll propose some changes. First of all, the change regarding the content of the message having to be of racial inferiority. I think that this would be a very narrow and would leave out several other types of hate speech. And then we go to the matter of intent, which I think it's a very complicated and a very complex legal concept. And the use of this concept for me would leave outside of this definition several types of harmful speech that kind of operate in a sort of gray area. So I tried to move away from that in my definition, right? And then here is my definition. I'm proposing those three elements. First, the message needs to convey an inferiority from the speaker in relation to the victim, right? And this, it's to allow this element to encompass as much situations as possible. So we can imagine a situation where a member of LGBTQIA plus community is being targeted with hate speech, but we can also imagine a situation where a member of a religious majority is targeting a member of a religious minority that is a protected group. Then we have the second element, still the same. It needs to be targeted at a historically oppressed group. And then the last element is that the message needs to attribute less dignity in relation to society. And that comes from this diving a little bit more into what's called the recognition theory that it's proposed by the man you see in the slide, Axel Honneth. And this theory basically described that the formation of an individual depends or presumes the recognition that we have from other people. And once we negate this recognition, I diminish the place of that individual, or if we're talking about hate speech targeted to a group, of that group in relation to society. So this element come in place so that we can include into the definition some more subtle or what we call micro oppression that reiterates structural oppression, right? And it does so because it recognized that this attributing this diminished situation, this diminishing relation in relation to society is a problem, right? And just to give a short example of how this would change things, here we have a tweet made by Jordan Peterson in which he has several photos of schools that were decorated in support of the LGBTQIA+ cause. And he captioned with "Keep your kids home, Canadians." This was, of course, not considered problematic by Twitter. And I think still some people would think that this is a harmless tweet. But this is just to give you an example of a type of content that nowadays it's considered to be inside the lines. And that I think it should be considered harmful. And this is the type of content that a change to include more subtle and more types of microaggressions would be included into a definition of hate speech. Of course, then, which is also something that needs to be discussed further in my research, what type of measures each type of content would entail, but I think this is a discussion to the future. Then we come into properly into the rights of the victims, because all this process of redefining hate speech is also that so that we can give more emphasis to fundamental rights other than freedom of expression, and that we can give victims a proper protection. I think that the first point that needs to be addressed here is that there is for sure a need to undertake more research to gather what is the victim's perspectives and to through that find out what are the legal goods in jeopardy once they are faced with hate speech. However, this is something that I haven't carried out yet, so I'll just stop here with this topic, but just to point out that there is that this is very important and central to the discussion. But nonetheless, I think we can already point out that non-discrimination is one of the main fundamental rights in this discussion. Here, I call it a quintessential victim's right. And that is because it relates to the sense of what I was telling about the recognition theory and how there is a need to reassess the way we address those minorities and to put those minorities in a situation of subjective equality. And then I think once you look into the legal instruments where non-discrimination is established, we can, or at least I found in my research that the way that platforms are tackling hate speech today would allow several types of content that would be in violation of international standards. However, the problem that we have with human rights and applying human rights to business today is that business have a very big incentive or whenever they have an incentive not to comply with human rights, they will do so because human rights are always subject to their business decision. I think a good example of this is the whistleblower by Frances Hogan, where we had Facebook for a while telling us that they were complying with human rights and that they were taking all sorts of measures to protect human rights. But then when declarations came up, we saw that the scenario was very, very different, and that even though they were saying they were protecting human rights, there were several violations or several problematic systems in place. So then we have a situation where how do we make to effectively oblige these companies to follow through with their human rights obligations? And then we come to why I think it's the biggest novelty in this extended abstract, and this is just me starting to interact with this theory. But in civil law, we have something called the civil constitutional theory, where you can find the principle of functionality, right? And this principle means, for example, you're going to have like the functionality of the contract or the functionality of the property. And this will be used to say that, for example, in the drafting or in the interpretation of a contract, there are certain legal goods that need to serve with guidelines. Equally, I want to, I mean, not exactly the same thing, but I want to propose that we should recognize to platforms a sort of social function, right? And I want to do so that we can shift the way that human rights and corporate decisions interact. So nowadays we have human rights kind of like in the backseat to corporate decisions, and then decisions that aim profit and aim to develop the company's goals are always above human rights. And I think it is necessary to make a shift into that relation and subordinate those corporate decisions to the legal goods that are protected by human rights, and to make the protection of human rights one of their goals, right? And I think that this principle of functionality might help us. This has also a very important effect when it comes to hate speech, is that it makes easier to compel companies to protect users against microaggressions and more subtle forms of hate speech that reiterate structural oppression. So I think, of course, this is in the very early stages of my research, and there needs to be a lot more discussed about this principle and how it would effectively be applied. But I think we can already see that this shift would bring a lot of positive consequences. I mean, as I said, this shift would likely face a very big political backlash, because I don't think we are in a political scenario. I mean, at least I speak for being here in Europe for a couple of years, and also from being Brazilian. I do not see a political situation where this type of proposal that changes so drastically the business model of platforms would find any traction. However, I think it's important to recognize that the problem is within the platform's business models, and and that platforms are part of kind of like this bigger and grander scheme of exploitation of our society, and kind of like this vicious relation that we've been creating with technology. I mean, as I said, those are some questions that I intend, with some others, of course, discuss in the future with my research. First, there is the matter of addressing the voices of the victims and the perspectives of the victims, which I think it's central to my work. Lastly, there is next, there is a matter of whether the way platforms are approaching freedom of expression today would be in itself a violation of the right to freedom of expression. And here it's a dialogue a little bit with discourse theory and a positive interpretation of the right. So I think like this can be an important question to be asked when we're talking about regulation. Then we go to questions that relate more to the fundamental rights framework, and for me, which is a very important question, is that like the current human rights framework that we have it's something that is result or came off colonial structures of oppression, right? So how do you deal with applying something that came from colonial structures of oppression to combat hate speech and the structural oppression caused by hate speech? So I think this is something that needs to be addressed. And lastly, I think there is a question of if, and that was addressed a little bit early by some of the other contributors, of will we ever be able to, in a capitalist system, change the way platforms function sufficiently so that the cycle of oppression that they are reiterating are ever broken or stopped? And those, I think, are some more broader questions that come up from this discussion. And honestly, I would love to hear the opinion of the other contributors and the people watching at home. I would like to thank Giovanni and everyone in the organization of this event. It's been amazing to watch the panelists yesterday, today, and it's been an absolute pleasure to be able to talk a little bit about my topic here. Thank you very much. If anyone wants to get in touch, here's my contact. Thank you.
Thank you. Thank you also for your perfect timing and the clearness of your talk. I will write in our private chat a couple of questions that arrived concerning your talk, so you will have some time to think about these questions, and hear you later. Thank you, Guilherme. So. We probably fixed some technical problems regarding the talk of Urbano Reviglio and Giulio Santoni.
Yes, can you hear me?
Yes, we can hear you. Welcome. Nice to see you again, and nice to meet you. So your talk is about governing your research and your paper and your talk is about governing platform recommender systems in Europe, insight from China. So I leave you 20 minutes to better explain your main research lines on this topic. And in the meanwhile, I collect some questions for you to discuss at the end of the morning. Thank you.
Okay, perfect. Thank you very much, Professor, for having us. I am Urbano Reviglio, a fellow of the Information Society Law Center, and I'm also glad to announce that I will be soon a research assistant at the Center for Media Pluralism at the UI. My co-author and co-presenter is Giulio Santoni. Can you hear us?
Yes.
Okay. Please present yourself.
I'm Giulio Santoni. I did my LLM in China, and I later did a PhD in Tor Vergata in co-tutorship with the China University of Political Science and Law on intermediary secondary liability in China and the European Union, a comparative perspective. Currently, I'm a scholarship visitor at the Max Planck Institute in Hamburg.
So we're working together now for a couple of months on this research we've titled Governing Platform Recommender Systems in Europe, Insights from China. I focus more specifically on the socio-technical and governance analysis, while Giulio focuses explicitly on the juridical analysis. So let's go straight to the point. So very briefly, I'd like to introduce platform recommender systems and the challenges their challenges to governance, just to be sure that we're all on the same page. Then Giulio will present the legal comparison between the Digital Services Act and the ISARM, which is the China's regulation on these algorithmic systems. We decided to focus on two main areas, which are algorithmic accountability and digital self-determination. Then I will also highlight the limits of the current platform recommender system governance before drawing preliminary conclusions. So, what are platform recommender systems? Of course, they are the algorithmic systems employed by mainstream social media, and we describe them as complex socio-technical systems that recommend different content format and types, including news, from a vast set of items using a vast amount of data and using machine learning. So we're talking about TikTok or Douyin, Twitter or Weibo, YouTube or Bilibili, and many others. So generally speaking, platform recommender system comprise of two main areas. One is content moderation and the other is content recommendation. They are both very much automated, but in both cases there is also a degree of human intervention. More specifically, these algorithms are pipelines that comprise more algorithmic systems that are very much complex. Consider just that Facebook's newsfeed has 12 trillion parameters. Okay, so the main concerns, as you may know, of course, it's the imperscrutability of these systems, the dominant role that they have acquired in online news consumption in the last decade, the fact that they may embed a number of biases, and they can also amplify disinformation or reduce media diversity. They can also manipulate users and create addiction, among other concerns. So briefly, the main challenges of the governance of this system is that, of course, they are black boxed. So they are difficult to study because there are trade secrets that need to be protected in order to this system not to be gamed by malicious actors or interested actors. Then it's very important to notice how they are mutable, because they're constantly tweaked and retuned constantly. So they're very difficult to capture for policymakers due to this transient character. They're also very much heterogeneous because, of course, they provide a personalized experience. So the effects may change from individual to individual, but also from culture to culture and from platform to platform. They're also a multi-stakeholder environment in which several different stakeholders come together pursuing contrasting interests. And finally, of course, it concerns freedom of speech, which is a very sensitive area for democratic society, while this is not the case in China. So traditionally, we have relied on liability rules, and therefore there was a sort of indirect and self-regulatory regime till nowadays. This year, the Digital Services Act and this ISARM have been implemented, and they are the first regulations to finally tackle these specific algorithmic systems. So a number of research questions emerged. So we were asking, what are the regulatory innovation of the ISARM? Because the media portrayed this regulation as highly disruptive because the Chinese government might also enter the code. So this was very interesting to assess. And what are the differences and similarities with the DSA? And eventually, what European policymakers could learn from the Chinese regulatory approach in order to improve the governance of these systems. So, Giulio, please, you can go on.
Yes. So, in comparing the Digital Services Act and the Chinese regulation, it is clear that the main difference is that the Chinese government has broken ice on two fundamental aspects of recommender system regulation. The first important aspect is that public authorities have the power to prohibit specific algorithmic practices and to intervene on platform design. They can assess security risks of platforms, which, on the other hand, in the Digital Services Act are based on self-risk assessment issued by the platform themselves, and they can prohibit specific algorithmic practices. On the other hand, individuals are given the power to somewhat consciously intervene on the output of content. So, the system of public accountability in China is based on the leading role of the state and focuses on the supervision by the CAC, which is a sort of ministry of cyberspace. The CAC has the power to identify which platform are information gatekeepers and tailor its response mechanisms in the so-called graded response system, regardless of whether these platforms hit or not an exact quota of users. This highlights a further important difference with the Digital Services Act, where platforms that are subject to additional accountability duties are the so-called very large online platforms, which are identified on merely numerical terms. So a very large online platform is one that has over 45 million users. The system of this mechanism used in Europe is quite rigid and could be criticized because many important platforms will fall out of its scope of application, insofar their importance derives not by the sheer number of the user, but by the quality of information they're distributing. More in general, the relation between platforms and the public in the Chinese system relies on the leading role of the state and coexists also with tendencies to collectivize data ownership. Researcher access is a great innovation in the Digital Services Act, and it is already implemented in China as well, where it is, however, performed under the direction of the CAC within the so-called big data ecosystems. These are joint research activities that involve government agencies, private and state-owned companies, and researchers from military and civil backgrounds who are enrolled in large projects, usually run at a provincial level, whereas different provinces compete with each other in order to produce the best research results. However, this system of accountability, or we could say even of observability, is overall closed, and it's closed from society as a whole, and therefore it traced the observability of algorithms for control and security, and it seeks its efficiency in that aggregation rather than participation from multiple stakeholders and carriers of different interests. There is an important public accountability measure in the ISARM, the Chinese regulation, which is that Chinese platforms are required to disclose the basic principles of their recommender system through a public filing system. So, as Urbano just hinted, many were suggesting that because there is this tendency in China to collectivize data ownership and perhaps even algorithm ownership, it could be possible that platforms were actually being compelled to disclose their codes. However, at least the information showcased on the CAC webpage is minimal, and it does not allow for a deep understanding of a recommender system. In fact, it does not comprise any information on the code, and we could say it's even of a limited importance for external researchers. Even in the Chinese context, this approach to research is problematic. So, as Urbano said, freedom of speech is not a central concern in the Chinese constitutional system. However, even in China, researcher access has the potential of empowering state supervision if and insofar it can provide different views and original thoughts. If on the other hand, researcher access is performed under the strict supervision of a government authority, it risks simply confirming the biases and mistakes that the regulators inevitably will make, without truly enabling researchers to contribute. With regard to individual self-determination, the CAC regulation focuses on two main dimensions that are deeply intertwined, and that are the self-determination of users, which is enabled through a rudimentary system for the selection of preferences, and on the other hand, some provisions aimed at preventing the manipulation of users by platforms. Interestingly, unlike the Digital Services Act, the Chinese regulation does not provide for a principle of algorithmic explainability, but it has a more practical approach. The system of preferences imagined in the Chinese regulation is quite rudimentary, but it could be argued also effective. It is based on the notion of tags, or biaotian, which are information that identify user preferences, but are not limited to personal or sensitive data. In lack of provisions that enable researcher access, we entered the Chinese version of TikTok in order to figure out what these biaotian are. as of today, as of February 2023, users are given a vast number of options based on personal tags through which to intervene directly on the recommender system. Personal tags are divided into macro categories such as food delicacies, humanistic sciences, and travel, which are in turn divided in subcategories. For instance, the category food delicacies is divided into scouting restaurants, enjoying delicacies, traditional snacks, and purchasing ingredients. Most provisions on addiction and manipulation in China are directed towards minors and other vulnerable subjects. However, vulnerable adult users are addressed in rules on so-called network ecology. While not openly mentioning internet addiction, several rules impose the demotion of content that is grotesque, exaggerated, vulgar, and sexually alluding. All types of content that exploit human attention. However, here the objective of protecting individuals from algorithmic manipulation and the objective to prevent the circulation of content that could be politically controversial merge. So this produces what we could call the paradox of network ecology, which means that rules that prevent the manipulation of user attention are designed to nudge users into some political opinions. So these are the main characteristics of the ISARM, and now I will give word back to Urbano for some conclusions.
Yeah, thanks, Giulio. So from this comparative analysis, we also have highlighted a number of limitations that I will just now present. So firstly, the methodological validity of social media research, because the problem is that it's very hard to prove causality of these systems in any of their effects. And therefore, some social scientists are arguing that we would need also to make on-platform experiments in order to assess certain kind of effects. And this could also become a potential promising approach regarding policy making. So, for example, Article 29 of the DSA, which would allow to have preferred options for users, could have been experimented inside the platforms with a number of samples in order to assess whether the certain goals were met or not. Secondly, in both regulations, they've not been tackled properly the problem of engagement optimization, which is the paradigm with which these systems are actually wired. It is they embed the business model of the platforms that they tend to create a number of biases, confirmation bias, and unintended effects. As of now, there are actually a number of alternative paradigms, such as the one of self-actualization, which would aim to better align user preferences and to try to escape the inherent reductionism of profiling technologies that they are ultimately pseudoscientific, and they're not able to, despite their success and their ability to engage, they do not align users' preferences in a satisfactory way. Relatedly, also the problem of the vulnerability, the systemic vulnerability of users have not been tackled fully because, of course, we must consider the bounded rationality of users, the information asymmetries, and the pervasivity of online manipulation, both by design and by algorithms. So in this case, there is still room to improve the detection, prevention, and legal codification of the phenomena related to manipulation and the vulnerability of users. In the European context, this will highly depend on whether platform recommender systems will be deemed to be high-risk systems, or even they may even be banned, some of these recommender systems. Another important point to make is the fact that content visibility moderation has not been tackled again in both regulation. By content visibility moderation, I mean when platforms decide to amplify or demote, or you can also use the term downgrade or even shadow ban certain content. These kind of decisions are actually very much widespread. Just recently, there has been a leak on TikTok that shows how they have a sort of hitting button that they just click in order to make some video go viral. And therefore, there is a lot of editorial intervention that is not widely recognized, and it's somehow underestimated, and there should be more transparency on this phenomenon. Finally, in both regulation, there is also little participatory governance. So users as a group of stakeholders are not very much included into the ability also to provide a second order accountability approach. Users are just provided with affordance to flag certain content, but there is much room to improve this kind of approach. So our preliminary conclusions are the following. Certainly, to begin with, we must say that time is needed to completely assess this regulation. Not only the DSA, which has been implemented more recently, but also in the China's case, there are a lot of technicians that need to be hired before to implement all the provisions. So there is a sort of lack of expertise that need to be prepared, as well as in Europe. But we can say that overall, the DSA and ISARM improve the platform recommender system governance, but there's still, of course, room to improve. We can say that in practice, the Chinese regulation provides more authority on these, more authority and more control over these systems, and it provides concrete tools for self-determinations that they tend to align with Chinese values. So the Chinese approach is more consistent with its own culture, and the tools that they provide, they are mainly for personal relevance, while in the European context, these tools are just left to platforms to implement, if any, and these are not required also to provide something that goes beyond personal relevance, but including also democratic values such as media diversity. So in theory, we can also say that the European Union could develop a more accountable and emancipatory platform recommender system governance if it will also include independent and open research, which is still disputable, and we need to see whether the framework of data access for research will be effective, and also by including more participatory governance from users that arguably in the Chinese context, it's less of a potential and viable option. So these are our preliminary conclusion. Thank you very much, and we look forward for your questions. Thank you.
Thank you, Urbano, and thank you, Giulio, for this wonderful presentation. I know that it's not easy to pack and to compress such important issues in 20 minutes, but I'm receiving a couple of questions that I will put in the chat, in the private chat for the last our final discussion. Thank you very much.
Thank you.
So the last but not least is our Cinema Ozigit, and she sent us a very interesting research proposal about deep fakes and the regulation of deep fakes, and we are really interested in these topics, as you can imagine, So thank you, Sinem, and welcome. And you've got 20 minutes, like all the other speakers, to try to highlight the most important findings of your research, or what are you planning to do? Thank you very much. You do not have got a presentation, right? So you talk.
No, I don't have a presentation.
Perfect. Thank you.
Thank you so much, Professor Ziccardi, for introducing me. My name is Sinem Özyiğit. I'm a PhD researcher at Yeditepe University. Deepfake is not actually my main area of research for my PhD thesis, but I am very much interested in this topic during this journey. So I am just trying to research a little bit on it to understand the technology and how to develop some preventive mechanisms to the spread of harmful content. In this presentation, I will focus on the regulation of deepfakes, as I said, and my point is that the regulation of artificial intelligence is actually topical at this point in time. However, deepfake has its own characteristics and challenges on so many different levels that drafting a single regulatory response to all artificial intelligence technologies unfortunately does not suffice to transcend the defect-related harsh effects. So my primary aim is to introduce the defect technology and to develop a detailed benefit risk analysis to reflect on the key discussions in the legal literature and various regulatory strategies developed across different jurisdictions, and to determine from my point of view the ideal content of the potential regulation dedicated to deepfakes. So let's start with the definition of deepfakes. We can see the definition of deepfakes in several materials, including the Artificial Intelligence Act, and also some revisions in the Digital Service Act. But I will define here deepfakes as text, images, videos, and sounds which seems to be authentic, but are wholly or partially produced through artificial intelligence technique like machine learning or deep learning. The first step in developing a healthy regulatory response to deepfakes is actually conducting a detailed benefit risk analysis. Thus, we will be able to spot which positive impacts need to be encouraged and which negative impacts need to be curbed by applying three-factor model, namely the severity of harm, the scale of harm, and the ability of the target to transcend the harm. When we conduct our research, I realized that actually there is a report published in 2019 which indicate that non-consensual pornographic contents constitute 96% of all deepfakes, and all pornographic deepfakes target women without any exception. So this is very interesting result actually. Although researchers have found in part of a recent study that men are also rarely depicted in non-consensual pornographic deepfakes, the fact is still that women are more vulnerable in practice, and that deepfake technologies have become a new tool of violence against women. Also, child sexual abuse materials may be produced in case the algorithms are trained by the images of child or the childhood images of an adult. So, considering the vast majority of deepfakes constitute severe interference with personality rights of children and women who are unable to cope with this level of harm, especially in countries where victim blaming is common. The focus of policymakers must be on non-consensual pornographic deepfakes first. In addition, strategies must be developed on how to combat misinformation and election interference, given not only the severity of harm and scale of harm, but also the lack of resources in the hands of public compared to the huge investment made by actors who support these campaigns. So these inferences actually lead me to the conclusion that national and international regulatory strategies, on the one hand, must appropriately respond to the adverse effects of three contents. One is non-consensual pornographic deepfakes, two is political deepfakes, and three is deepfake information and news. On the other hand, these strategies must provide for a mechanism whereby freedom of expression is safeguarded, and various sectors from film industry to medical industry are able to enjoy sector-specific benefits. Taken together, the main challenge of the regulation of deepfake is actually how to resolve the tensions arising between these relevant interests at stake. The regulation movement has actually started in some countries actually, and in my paper I divided jurisdictions into two groups. The one is jurisdictions offering piecemeal solutions for three major risks, And the second one is jurisdictions designing more general omnibus regulations. When we look at the countries who are offering piecemeal solutions, we see that some countries focusing on non-consensual pornographic deepfakes, the others are focusing on political deepfakes, and the rest is focusing on the misinformation campaigns. Especially the U.S. state of Virginia is quite interesting in this sense, and it regulated the deliberate distribution of non-consensual pornographic deepfakes as a crime. And also we know that the UK is also planning to criminalize the distribution of non-consensual pornographic deepfakes. But when it comes to non-consensual pornographic deepfakes, some jurisdictions are using some civil law mechanism to combat this risk. And for example, the United States developed a civil action. Actually, the California state in the United States developed a civil action which can be filed against individuals who deliberately distribute non-consensual deepfakes. And also New York revised the scope of personality rights and allowed for post-mortem protection of personality rights as a response to deepfake. When it comes to political deepfakes, actually two states of the United States are very engaging in this risk. They are Texas and California. Texas and California prohibited the distribution of deepfakes of a candidate within 30 or 60 days, respectively, before an election, with the intent to injure the candidate's reputation or to influence the election results. In this part, actually, California is bringing a more detailed regulation, considering that it expresses that the reasonable person test is applicable when evaluating whether a content is materially misleading. Content that includes a statement like this picture, video, or sound has been manipulated is deemed to be lawful as long as it appears in a size that is easily readable by the average viewer. So I think California, in this sense, constitutes a good sample for other countries, since it brings some standard for the labeling or obligation of the deepfake creator. And some countries actually, as I said, focus more on deepfake misinformation, and those are actually developing more like strict measures, like Turkey. In Turkey, deepfakes is seen as a misinformation campaign tool. So the government recently enacted a regulation saying that dissemination of fake information and deepfakes may be seen as a crime if the user of the deepfake technology intends to disseminate fake information or try to interfere with the public order and so on. So I think this is quite far-reaching regulation, considering that using the criminal law tools on the users are a little bit heavy on the users, but it is also inefficient to make the policymakers to reach their goals to prevent the misinformation. But we also see other countries, they are more flexible, like Taiwan. Taiwan think that misinformation is not a criminal activity right now, but we can fix this problem by using some extra legal methods, like spreading the correct news. They actually develop a method and they try to spread the correct information faster than the misinformation, so that the public can actually reach the correct information before the bad intents, the bad actors actually interfere with the public order, let's say. So in this sense, actually, we can think that always we can develop different approaches, in the sense that the measure shouldn't be in the legal territory, but we can also find other preventive mechanisms outside of the legal structure. But when it comes to China and the European Union, actually the scenario is a little bit different than the rest of the jurisdictions, because those jurisdictions are trying to bring a general deepfake regulation. But the thing is that we normally feel Brussels effect when it comes to regulation of technology. However, here China is taking really enthusiastic steps to regulate deepfake. For this reason, we will put a little bit more emphasis on what China is doing right now regarding deepfakes. The difference here is that the European Union is actually trying to regulate deepfakes in the minimum way, and it also says that their objective is actually providing a minimum transparency when it comes to deepfakes. So Article 52 of the Artificial Intelligence Act says that an abstract labeling obligation is enough to regulate deepfakes. However, it is quite controversial that this vague standard is not actually effective to inform the society. So like California state of the United States, we should bring more details. We should clarify the details of the labeling obligation. China is doing actually this one. I mean, China is bringing a standard for labeling obligation. Unlike the European Union, China does not specifically focus on the users, but it also focuses on platforms and deepfake creators, like the deepfake producers. So here the difference is that we can't just focus on the users to regulate deepfakes, but we should sail a little bit away from the safe harbor rule and to include platforms to the game to see how we can handle with the problem. Here, some actually reports suggest that we should classify deepfakes as a high-risk AI system, and also the platforms need to comply with an obligation of labeling as well, like the users, and also those researchers also said that on the individual level, the deepfake may be banned to undermine the disseminating of the fake news or deepfake pornography. Here, my opinion is that we should wait and see a little bit more on the detection technologies. Right now, the success rate of detection technologies are 65%, but I believe that there will be research and developments in that field. If it is possible to raise the success rate of the detection technologies, I believe that we can still use on the individual level the deepfake technologies, but we can impose an obligation on platforms to detect deepfakes on their ecosystem. Actually, we also see this approach in Digital Service Act. Recently, Digital Service Act also brings some limits on the safe harbor rule, saying that the platforms need to control the contents created by the users, and also China is doing the same thing right now. So we can also think of that the burden on labeling may be put on the platforms as well if they efficiently use the deepfake detection technologies, and of course if there is a development in that technologies. But the side effect of this approach is that if we put so much emphasis on the labeling obligation, and if there is no labeling, the public may think that contents which are not labeled by the platforms or by the users are correct. This inference is also damaging if there is a act of fault or any other incorrect decision on the side of the platforms. The public may think that the information is all correct, but we should just try to understand how these detection technologies work, and also we should support human intervention if possible, and also trusted flaggers are playing an important role here. It is a quite challenging area actually, but we definitely need to revise our national codes, like our criminal codes, our data protection laws, our civil laws, to adapt challenges posed by deepfakes. But of course, they are not enough right now. The individual regulation should be enacted as soon as possible. But I believe that it is very much connected to the development of the detection technologies. So we should just also encourage researchers in that field to produce more materials on how detection technologies work, how they can be improved, and how can they improve our content moderation system. So this is actually quite like a summary and the first thoughts on my research, and I would be very happy to answer your questions in the discussion part.
Thank you, Sinem, for your clear research description and for your presence here. And it's really a very important argument, the deepfakes, because it involves not only a problem of regulation, but also a problem of fake, and so of reality, and also of technology that is really evolving a lot. So I received several comments and questions about your talks. So I will ask to Guilherme to join me on streaming again for 10 minutes of discussion about the two topics that are related to your talk. The first point is if you are planning in your research to analyze some reinterpretation of the right of freedom of expression, or if you find some theories in your opinion that are how to say better for the complex IT legal framework. And the second point is if you think that freedom of expression today in platforms and in the IT society is really in a big crisis related to the spread of hate and how to say harmful contents, or if there is space today, there is still space for example, Article 21 in Italy, but all the, as you probably know, all the norms that in constitutional charts put freedom of expression as the center of our daily life, also as citizens in democratic institutions and countries. Please, 10 minutes to focus on these two topics. Thank you very much.
Okay, thank you, Giovanni. I think those questions are really, really good, and they go super well together. With the first one, he's talking about the reinterpretation, and that is something that I hinted by the end of my extended abstract. And by that, I meant two things, right? I think there is a first element of it that we see usually on platforms, freedom of expression being referred to in its conception as a negative right. And I think when especially we're discussing hate speech and other types of harmful content, I think we cannot disassociate the freedom of expression from its social impact, so that we need a more positive approach into its regulation, in the sense that we do not only want to refrain from intervention in that right. We want like positive action in this case from the platforms, but we can also think of positive action coming from the state to protect those rights. And I think this is going to be a perfect segue, because I was reading some of the contributions during the week that just passed, and there is one of the articles by Sharon Basson that will be this afternoon presenting her work, and I think that's that is a really good article to show and to kind of like understand this need that freedom of expression is just we're not actually protecting freedom of expression once we have a situation like hate speech and people that are being segregated and relegated to a situation in relation to society where they're not valued as equal, and therefore their opinion or their ability to contest that, because it's very easy for me, right? I'm come from a very privileged place, so like if I'm faced with something that I might find that it's like aggressive toward my person, I will not feel this diminishing. But if you're talking about someone that comes from one of those historically oppressed groups, then you have this kind of distortion and this effect of diminishing their place in society. So I think this reinterpretation is meant, first of all, in this way. And I think there is a second part of this reinterpretation that relates to what I talked about in kind of like the last point of the presentation, or the second to last, to how do we think of the current human rights framework that we have, that is coming from a background of a colonial system, right? So that's also something that might play a role into this reinterpretation. As to who should do this interpretation, I think that when we're talking about hate speech, I think the easier way or the more effective it would be if companies by themselves decided to adopt those different standards. But again, we see that convincing companies to do so might be very difficult. So we might be looking here into a mix of self-regulatory changes with also some regulatory changes imposed by the states, or in the case of Europe, by the Union. And then I think this kind of like already leaks into the second question, because he asks if there's still space for freedom of thought and freedom of expression. I think that, of course, we are in a very difficult scenario nowadays with fake news, with hate speech, with deep fakes, and we've been through part of this with the issues with recommender systems. Like, so we've been through several of those aspects with the contributors here today, and. But I think there's undoubtedly there's still place, and we see a freedom of expression being used to uphold several causes that are very important. So you have the LGBTQIA plus fight against censorship and etc. And you have several other areas where both freedom of speech or freedom of expression and freedom of thought are very important. Even though I recognize that we are in the middle of this whirlwind of hatred and fear that he speaks about. And then what kind of actions could be envisioned? I think that is a little bit what I touched upon in the end of my slides when I was talking about the introduction of this of the principle of functionality, and trying to find a way to hold companies not liable, but like put companies in a position where they have inside their structures human rights as kind of like a guideline. I do understand that again, his question seems to have a very realist approach to the topic, and again, it's something that it's very, very politically difficult, but I think we start to see some changes, and I think that the main takeaway from so for example, you have the DSA now proposing some new measures, and then you have measures regarding human rights impact assessment and transparency, and of course, like all of those will have to be analyzed in the future regarding how they are executed, and how the enforcement of this new legislation it's going to work. We have the same thing going on in Brazil with new legislation to combat harmful speech and to combat fake news. But again, all of those are subject to enforcement, right? To the problems of enforcement. So I think that is a question to look more into, how to improve enforcement, so that those new legislation coming up can kind of have the desired effect. And I think for me, the biggest takeaway of if I had like to leave everyone with one takeaway, is that like maybe it's now start thinking of both legislation and kind of like structural changes to the companies that change more drastically the way companies operate and their internal business models, and that give more space and voice to the victims and to the users. But yeah, I mean, I would definitely say that agree that freedom of expression is in a crisis, and that it is kind of like mingled with several problematic effects or several problematic situations in our society nowadays. But at the same time, I think you can see the pushback in several places, and I think like pushing forward the agenda to recognize these problems is very, very important. I think if we don't have, I don't think we have any other questions. If not, I think
thank you very much.
Yeah.
Thank you also for this final part. Of course, if you've got some question for the other speakers, especially Urbano, I saw that you followed with a great attention our conference. So, of course, if you've got some questions for Urbano and Giulio and Sinem, feel free to write in the chat, and we will forward also your questions.
Perfect.
Thank you. Thank you very much. Thank you again. So, Urbano and Giulio, we received one question about commercial profiling for commercial purposes in China, because I think that in the common opinion, Europe is for rights, US, especially California, is for consumers and commercial approach, and China is for control. So usually the idea of profiling for commercial purposes in China is not always in focus. So I think it's very interesting, the question, if what do you think about the framework of profiling for commercial purposes in China, and the difference, in your opinion, between Europe and China on this point? Thank you.
So I will start replying this question. And so in China, the problem of commercial profiling falls within the Personal Information Protection Law issued in 2021. It is a law. It is a law that some scholars have framed as the Chinese GDPR. However, it is characterized by some important differences with the GDPR. The first one is that there is no principle of privacy by design, and also that transferring abroad data gathered by Chinese companies is much more complicated than under the personal data gathered by Chinese companies is much more complicated than under the GDPR. The Chinese Civil Code, which was also issued in 2021, provides for a very detailed list of personal rights, including a right to privacy. However, these rights are not provided with some tools for their enforcement. So they mainly rely on liability rules to be enforced. I believe the true difference between the European and the Chinese system lies, however, in profiling by the governments rather than profiling by commercial entities. So China has followed Europe to some degree in providing individuals with a degree of protection for their personal data. However, these protections do not apply from profiling do not apply to profiling by the government, which means that also profiling for commercial purposes that happens under the umbrella of state-owned enterprises falls out of the protection of the Personal Information Protection Law. Finally, another difference in this regard is the so-called social credit system, which has been very much talked about. So Roger Kremers, which is one of the main European experts about Chinese data protection laws, has argued that the social credit system has not yet developed its full potential, and that mostly exists as a sort of coordinated effort by different Chinese provinces, which are experimenting with their own social credit systems used for different purposes. However, this year, a draft social credit system law was issued by the Chinese government. So it is possible that these localized social credit systems will be united in a nationwide system. And with regard to content regulation, I believe that the main difference between China and the European Union is that content moderation in China is based on the existence of monitoring duties that Chinese platforms have. So First of all, the Chinese cybersecurity law includes a long list of content that cannot circulate online, and these include both content that is damaging the public interest, as well as content that is damaging individual rights. Furthermore, and this has in turn an important effect also on civil lawsuits in China arising from the distribution of content, because the Chinese Civil Code provides that platforms are liable when they know or should have known of a civil right infringement. I would like to underline that the reason why Western legal systems have so far avoided imposing monitoring duties on platforms has been framed by some US scholars as the risk of secondary censorship. So we avoid imposing monitoring duties on a platform because the speech that the platforms are carrying is not their own speech, and especially when the monetary value of this speech is very low, platforms could receive excessive incentives to remove the content. So what I found reading some Chinese cases is I think quite interesting in this direction, because it is true that in China platforms are often found guilty for failing to perform their monitoring duties, and so they're charged of negligence-based liability. However, the damages compensations tend to be very low in China and determined to the judge by equity. So there are, for example, cases in which these damages compensation are so low that they're not high enough to convince the platform to actually remove the right infringing content. So I believe that it's quite interesting to notice that even in the Chinese system, where, as I mentioned before, freedom of speech, of course, is not a core value, there are some measures taken against the risk of over censoring.
Perfect. Thank you very much, Giulio. I've got a question for Urbano. In the last years, as scholars, we had a great difficulty to find original sources in our studies coming from China. The first problem was the language barrier, of course, but also it was very rare to find scholars like university professors in China analyzing first the firewall system, then the control system, then the social scoring system. I'm curious to know if in your last 2 or 3 years of research about these topics, did you find a difference in a different framework? If it's easy today to find, for example, the official translation of official acts in China, or studies coming from Chinese universities of scholars criticizing also the framework, or if it's still difficult to do research on these topics using original and local sources.
Well, this is a question for Giulio, I guess, because I rarely stumble upon Chinese sources, to be honest. And so, Giulio, please help me.
Yeah, it's still quite hard, even when one has access to Chinese universities to find material regarding some of the topics that are most interesting in a Western perspective. There is, however, an increasing number of official translations, for sure. Also, case law, which previously used to be very much secretive, is now available through some web pages. Some of them require paid access. Others, such as there is one called Beida Fa Bao, which is a big like Chinese data set of cases, laws, regulations is available through most of the portals of Chinese universities, which is not always easy, also due to technical issues. For example, I need a VPN to access it, and currently the VPN is not working. I mean, there can be also some technical difficulties. There is an increasing number also of European scholars that are researching on the Chinese legal system. There is a web page run by the Stanford University, which is called DigiChina, which is offering some translations. For example, they translated the IISARM, which is the main regulation that we studied in this article. And they also translated the Chinese cybersecurity law, and they provide some insightful comments.
So it's possible today for a young scholar, for example, to find an interesting amount of sources and documentation to study these topics, right?
Yes, I think it is.
Okay. Thank you. Thank you very much. Thank you, Urbano. Thank you, Giulio, for your work and your presentation. And now we close our session with Sinem. And thank you very much, Sinem, for your presentation. There is a question coming from a fellow who is expert about terrorism. I don't know if it's your research topic of study, but he is asking if what do you think about the use of deep fakes for terrorist propaganda, and generally, I mean, for the creation of hate and harmful contents that could help to spread these contents and to create problems in the democratic society. Thank you.
Yeah. Thank you so much for this question. Actually, my area of research is civil law, but I am so enthusiastic about thinking on other fields of law as well. So this question is also very much interesting, and I may share some let's say information about the use of deepfakes in that field. Actually, this is not a theory. It happened in practice. As far as I know, in European countries, in the Netherlands, it is used for some intelligence activities by foreign actors to receive some information from the from the high level of persons, as far as I know. We don't know which information was shared, but we know that there was an online meeting with the actor, with the intelligence actor, and with the officials in the Netherlands regarding some sensitive topics, I guess, but we don't know the details. It's actually used for that purpose. Also, we know that in the war, Russia or Belarus also used against Ukraine deepfake technology, some deepfake accounts to share some news and information against Ukraine. So we know that actually we have examples for this use for intelligence activities and for terrorist activities. And also I would like to share that FBI announced a warning recently saying that there was some LinkedIn job offers which were actually an artificial intelligence created, and they were just collecting personal data of the applicants for the fake jobs to use for some other bad intent, let's say. We don't know actually the use of this data collected from that job offers, but we know that these are actually used so much in practice. I can say that actually it is not easy for me to give a clear answer for that, but I may enlarge the scope of the question. Maybe I'm thinking that, for example, how we can empower the prosecution authorities which discretion we can give, or the admissibility of the evidence in the criminal jurisdiction, or how we can create a cooperation field for different countries. For example, we can say that, for example, through bilateral agreements, two countries may promise not to use deepfakes for intelligence activities, but we don't know how they can comply with this obligation. And also, if you have a bad actor, they will always find a way to circumvent those rules. Also, this is another question that, especially in the criminal cases, we know that if there's a suspicion, that person will benefit from that suspicion, and the deepfake is actually a tool for this suspicion. You can say that an evidence is deepfake, so you can convince the courts that you can just rely on that evidence. But we also don't know how to detect that nature of the evidence. Let's say that the success rate of the deepfake is 65% right now, and which is quite low. So we can't be 100% sure that this evidence is authentic or deepfake. So for me, right now, in that level, in the criminal law matter and in the online terrorism activities, this is a huge challenge right now. We definitely need an international cooperation there. We need to to some extent harmonize our criminal law system, especially in the sense that the admissibility of evidences, the role of the prosecutors. For example, another ethical question may be, can the prosecutors use deepfake to investigate the potential crimes? Can they interfere with the Web3 environment by using deepfake to investigate child pornography, like child sexual abuse crimes? So this is also an ethical question that we should ask, to what extent our judicial system can use deepfake to combat crimes, let's say.
Thank you very much. Thank you, Sinem, and thank you to all the speakers this morning. So I declare officially closed this morning session of the second day. If someone is following us, I see that someone is following us online. We will restart at 2 p.m. For the fourth session of the conference with the chair Samantha Stanco. And thank you very much to all the speakers for their wonderful presentations, and to the followers and the listeners. And see you and hear you very soon. Thank you very much.